Good morning. Welcome to the House Judiciary Committee Subcommittee meeting. If you were here for the Religious Freedom Bill, it is not on the agenda due to a scheduling conflict with a sponsor, and we have two bills on the calendar this morning. We have a judicial security bill, and I'm proud we have a member of the Georgia Supreme Court here, and any other members of the judiciary we have here this morning. Thank you for coming. We've got an adoption-related bill also. So with that, I'd like to call on Vice Chair Silcox to deliver our invocation.
Shall we pray? Dear Lord, we thank you so much for this beautiful day. We thank you for the opportunity to hopefully improve the quality of life for all Georgians through passing wise legislation. Just give us guidance in that, and not all we do, that we might glorify you. In Jesus' name, amen.
Thank you. All right, Senator Dixon, tell us about the judicial security bill. Good morning.
Yeah, today I bring before y'all Senate Bill 508, and what it simply does is it would require or add to the duties of the administrative office of the courts to restrict accessibility on personal information for federal judges, justices, their spouses, state judges as well. And simply, would restrict their address, their phone number, personal information from being, accessible to the public. As many of y'all know, myself and several of our colleagues under the Gold Dome here were swatted over the Christmas holidays. Our judges, the decisions they have to make, on a daily basis. I know very little of what all they have to go through, but can imagine the threats and things that come across, at their families and all. So this would just help protect them. I'd be happy to answer any questions.
Thank you, and thanks to your work, Senator Dixon, swatting will get investigated, and swatters will be apprehended and put in prison. So thank you for what you've done on that, as well as bringing this bill. Do we have any questions for Senator Dixon before we hear from any folks to testify about the bill? No questions at this time. Do you have some folks who are going to be speaking in favor?
I believe I do.
All right. Come on up, Mr. Justice. All right. Thank you. Thank you so much. All right. Anybody
Sorry for
else?
that lengthy testimony.
Anybody else want to speak to the bill? Thank you, Senator Dixon and Judicial Council and Georgia Supreme Court. Do we have a motion on this bill?
I'll make a motion. Second.
We have a motion and a second. All in favor, please say aye.
Aye.
All opposed? All right, the bill passes to the full Judiciary Committee.
Thank you very much.
Thank
and
you.
If you would, and be honored if, Mr. Chairman, if you would carry the bill.
Absolutely.
On the House side.
Anything I could do for security on our judiciary, I'm glad to help you in that effort.
Thank you very much.
You.
I appreciate it. Thank you,
Appreciate
committee
it.
members.
You bet. Thank you. All right, Senator Robertson, tell us about this adoption-related bill.
Moving a little slow. I played flag football this past week, and played like I was 22 instead of 62. So moving a little slow.
If you hadn't said it, we wouldn't have noticed. You're doing just fine. Keep doing what you're doing.
Yeah, that grumpy look is just different for different reasons today. Mr. Chairman, I appreciate the opportunity to bring this bill to you. I think it's going to be familiar to you. We passed it out of the Senate last year, got it over here. You guys passed it out and got it over the rules, and we know how things get tangled up either with time or misinformation. And basically this bill being extremely simple. In the state of Georgia, Georgia is a locked state. In the state of Georgia, if you adopt a child at birth, when that child turns 18, if they want to go and get their birth certificate, they must hire an attorney, go to court, and get a court order from a judge to do that. I'm a big believer that what identifies us is the biology in our bodies, the chemistry that runs through our veins. Whether we grow up with our biological parents, which I was blessed enough to, be born to a mother and a father, and always knew, my Scottish heritage, always knew family history and all this other stuff. And then in the world of adoption, these children grow up in a world not necessarily knowing everything that their mind and their body's telling them they should know. And so when they start down this journey of research and they start down this journey of identifying who they are, when we put obstacles in their way when they're adults and 18 and want to go and get a birth certificate, I think we're doing them a disservice. So all I'm asking is that we move this obstacle out of their way. They go as if Randy Robertson went to the health department and asked for a birth certificate. I ran into this during off session, this past session, where an adoptee was attempting to get his second birth certificate, not his first birth certificate, and they kept sending him the wrong birth certificate, and he was trying to go on a cruise, and I reached out to Vital Records, and Dr. Toomey, who ran our pandemic response, took it upon herself, called me at home and said, I'm going to handle this. And within several weeks, we untangled a whole lot of kudzu and wiring and was able to get this young man what he got. Luckily, this young man works at a place that a state senator takes his vehicle to be serviced, and he knew of somebody to ask. And this state senator knew where to call. The vast majority of Georgians that live in this state, especially those that raised up in adoption, they don't have all those connections and they don't have all that information. So, but they deserve it, just like the rest of us do. So all this does is give them the opportunity when they turn 18 years old to be able to go down and get their original birth certificate.
Thank you.
Yes, sir.
Any questions for Senator Robertson? All right, we have okay. Representative Evans.
Thank you, Mr. Chairman. Thank you, Senator. The gentleman, and I thank you for bringing the bill. It always hurts my heart when people with connections can get things when other people can't, because most people don't have connections. But the person that you're referring to, they were adopted in a closed adoption, but they were able to get their birth certificate without a change in law.
Right. What happened was the system was kind of messed up. He was adopted, and then after he was adopted, his mother waited and changed his name afterwards, used a different attorney, and of course this young man's in his late 30s now, I believe, mid to late 30s. And so those records ran parallel. They were not merged together. His adoptive father committed suicide a few years back. His adoptive mother gave him a little bit of information and then kind of locked down on him. She told him who his biological mother was, and that was incorrect information. Or, she told him who his biological mother was and who his biological father was. The father information was wrong. And so when he went to where he thought he could get his birth certificate, he gave him his name. And the name that this young man has been signing everything on and living everything on was his name was never officially changed by the state of Georgia, even though he had driver's licenses and everything else. So Dr. Toomey getting involved was the part that brought this together. But the happenstance, and we've had other issues where adoptees have gone down to get it and they said, sure, go get an attorney. And, as you know, attorneys specialize in certain areas, and there are not that many attorneys that really want to delve into this arena. And I don't mean this to sound cold by any stretch of the imagination. I mean, it's basically pro bono work for the most part with these individuals, and it's time consuming and it's emotional. And so we were able to get that problem solved, though we had to correct a few other things and move some things around. But what I would like to do is just streamline the system for both sides, and I've had to go and retrieve birth certificates for myself and my children, and it's not been any issue.
No.
And currently, this has nothing to do with me carrying the bill, but I have a 5-year-old daughter, and I have both of her birth certificates. And when she's the right age, we'll give her both of her birth certificates. But I just think these individuals should have the same opportunities.
Sure. Is it that you can do it now, but you have to have an attorney, and
Yes,
this just
ma'am.
takes the attorney out?
It requires a court order.
Okay.
Yes, ma'am.
So we're not, I know there's been some concern shared that we're going to upend, people are not going to want to do adoption anymore because we're going to open them up to sunlight that they wouldn't otherwise been subject to. That's just not true.
No, ma'am.
This just takes the attorney out.
Yes, ma'am. And you have to be 18 to go and do this. So this isn't some, 8-year-old who's mad at his mom and says, "I'm going to show you. I'm going to go find out who my birth parents are,"
Right.
and runs out of the house. But this is an 18-year-old adult, and we're very sensitive to closed adoptions, and you know, the concerns that mothers, particularly mothers that put their children up for adoption, the emotional stress that they go through, and we don't want to disrupt that. And the vast majority of adoptions in Georgia are newborn adoptions, so we're looking in 18 years. Yeah.
Thank you.
Yes, ma'am.
Thank you, Chairman. Just on that, gave me a question. Currently, and I don't do this type of law, so I'm not really sure, but is it just a procedural process where you go and file a motion or an application with the court and the judge grants it, or are there certain requirements that you have to show for the judge to open up the records?
My understanding is you go before the judge and you have to make a case as to why you want the birth certificate. And, you know, our Superior Court judges are very hypersensitive to, you know, making the wrong decision, which I appreciate that, and they should be. And in some of these cases, it's like Representative Evans just brought out, is that, you know, this is 18 years later in many cases, or 14 years later in many cases, and the judges just want to make the right decision. And this, I think, clears the path so that the right decision is they don't have to worry about that. But I've not heard of a case where a mother or father who put up a child have gone to court and challenged somebody asking for a birth certificate. But you know, attorneys can be expensive depending on where you live. And what we find is that a lot of these individuals seeking to do this are doing it just to figure out who they are. And in many cases, they don't have the money to pay. $500, $750, $2,500, and in some cases more than that, is a lot of money to some of these individuals wanting this information.
And just curious, do you know what those what the reasonings are for that when they're making their case to open up their records? What
Well, a lot of it is they just feel they have a right to know where they came from, and they're having children, and they want to be able to tell their children. But another huge part of it is health history. You know, just knowing where they came from. And in some cases, this is not a bill to force any type of reunions. But I don't doubt that in a percentage of these, it is an opportunity to try to locate a sibling or somebody else within their biological family. Yes, ma'am.
Representative Silcox.
Thank you, Mr. Chairman. Thank you so much for bringing the bill. I had the honor of writing recommendations for my law school roommate to adopt 2 children. So, and I've gotten to know them really well, and it's been really neat because in both cases, when the kids turned 18, they, and I think it's normal to some extent because they start becoming their own people when they're, you know, in high school. And there was a little bit of rebellion in both the kids, and they ended up voluntarily, with the permission of the birth parents, introducing their children to the birth parents. And it was so healing for both of those kids because they, as you said, they know where they're from now. And the daughter did have a health issue that she was able to identify through with her genetics from her real mom. And so I just think this is a really thoughtful bill, and I think for the mental health of these young people, I think this is really, really great. So
Thank you so much. I agree.
Any other questions from the committee? All right. Thanks for your testimony, Majority Whip Robertson. We have several people signed up to speak. All, it looks like, are in support. So we'll start with Jamie Weiss.
Good morning.
Good morning.
All right. Thank you, Chairman Reeves and members of the committee. So SB 64 is a good bill, and it just does one simple thing. It restores the right to adoptees to their original birth certificate, just as they had prior to 1961. In order to clearly understand what SB 64 does, I wanted to walk you through the process that a birth certificate takes during an adoption. So step one, obviously, a child is born and a birth certificate with the facts of their birth is issued. The certificate belongs to the person whose birth is recorded on it and not to the person who gave birth. So it is a birth certificate, not a birthing certificate. And then step two would be if a mother decides to surrender her child, she would sign to terminate all of her parental rights in perpetuity. And here is what the mother agrees to. Some of the language there says, I, the mother, or the undersigned on some of the papers say, do relinquish all rights, title, and claim to the child, it being my wish, intent, and purpose to relinquish absolutely all parental control over said child. I do furthermore expressively waive any other notice or service in any of the legal proceedings for the adoption of said child. So at that point, all of her rights are terminated. I also would like to point out that that language that is agreed to, that is on that surrender of rights, that is the same. This is our current form. What's the second page to that? This is the same form, same language from 1970s, and the same form and language from the 1990s. So just wanted you to be aware that through the decades, it's the same agreement. What you don't find in that form is any promise of secrecy or anonymity. There's also no guarantee that the child will be adopted. So when they relinquish their rights, the child is then available for adoption, but could remain in the foster care system. Okay. So at this point, a relinquishing mother's rights are completely severed, and she is no longer legally connected to the child in any way or has any say in their life. The child retains their one and only original factual birth certificate, and that includes the mother's name. This is after relinquishment and after the termination of rights. This is the birth certificate that's used by the child and their guardians for any identification purposes. So if this child is in foster care, they need that to go to school or, whatever it is that they need a birth certificate for. So after that, here's our options of what might happen to the birth certificate. So option one would be the child remains in foster care and may age out. They keep their birth certificate. Option two, they can be adopted and no amended birth certificate issued because the adoptive parents can actually request to keep the original. Okay? So they would keep their birth certificate. That may not stand up right. But you get the idea. And that option for the adoptive parents is on this Department of Health form, number 3927. Right here on the back, they can just check mark where it says a new birth certificate in the child's new name, which shows the adoptive parents' names will be prepared unless the box below is checked. And if you check the box, it says do not prepare a new certificate in the adopted child's new name, which shows the adoptive parents' name. So the adoptive parents are the ones who have the decision to make of whether or not they want an amended birth certificate. The biological or birth parents have no choice or say in that. If an amended is issued, then that original is sealed. And so that's our third option. So only people who are adopted, whose adoptive parents make the choice to get an amended birth certificate, are the ones that are sealed. So I hope that you can see with that there is no way for the state to have ever been able to guarantee or promise secrecy or anonymity from someone's own child. And I know that is what the concern that people typically express, but this is the process that birth certificate goes through. And I hope that is helpful. So, originally the sealing of birth certificates was to keep the information available or not available to the public. It was not in order to keep an adopted person from knowing their own identity or origins. So I'm just asking you today if you'll support SB 64. It is a very good bill, and it's time to end this injustice that the state has in place. Thank you.
Thank you, Ms. Weiss. Representative Silcox.
Thank you, Mr. Chairman. I was just curious. You said that the mother's name is on the birth certificate, but the father's name is not on the birth certificate?
It could be. It would just depend on the situation. When someone gives birth, the mother gives birth, her name would automatically be on the birth certificate. If there is a father present, he would be on the birth certificate, or if she's married, that's automatically the assumed father. If there's no father present, he has to go through a process of acknowledging paternity to be put onto the birth certificate.
Okay, thank you.
And I'll bring back a memory from that guy right there, Wendell Willard. A paternity action, that's when the dad is the plaintiff. A legitimation action is when the dad is the defendant. So that's how the birth certificates get the dad on there, either one of the two.
Perfect.
Representative Hong.
Those options, thank you for that. That actually helps a lot. When you are adopting the child, is that when that decision is made by the adopted parents of whether or not to keep the original or to have an amended? And can you go back at any point, or is there an option to be able to do both?
We do have two adoption attorneys here who may be able to give better clarification on that, but this is what they have to fill out.
Chairman, is it possible for us to get a copy
yeah.
of that if that is that?
Yeah.
Thank you.
I could answer Representative Hong's question. The 3927 is filed by the attorney of record, and that's when.
Come on up to the mic.
Excuse me.
I bet you're signed up. If you can tell us your name.
I'm Jim Outman, Outman. I've been here since the Adoption Act of 1977, which put these forms into the statute, and have been involved in every adoption legislation since 75. That form is when the parent elects. I've not had adoptive parents elect not to give their child their name, so it's very atypical that an adoption would be completed and a new birth certificate would not be issued. That's an exception. There's no way to go back that I'm aware of. Clarifying an earlier question that was posed to Senator Robertson, the action when I filed suit against the Department of Public Health, and that's what the procedure you have to do, and I've had clients come to me that have been to many attorneys and come and said, I can't find an attorney that knows what I need to do. And I've been quoted $5,000 and whatever because they didn't know what to do, so they raised the price to figure out how to educate themselves. It's a suit against the Department of Public Health. The Department of Public Health offers no opposition. Typically, I get a consent order with the attorney representing the Department of Public Health, present it to the judge, and it's done. If you roll the dice and go to a judge, we have over 200 Superior Court judges in the state, you may have one saying, well, adoptions are sealed, to hell with that, we're not going to allow you to know your name. So unfortunately, some people pay the money and get to the court and get the wrong answer. So this bill eliminates that arbitrariness. The statute does not provide a standard. Doesn't even say good cause. It says you need a court order from a court of competent jurisdiction. I had one judge said, what's a court of competent jurisdiction? I said, you are, Your Honor. But, so hopefully that answers the question. Another thing I'd like to emphasize is 50% of the adoptions in Georgia each year are step-parent adoptions. So the comment was made that in a majority of adoptions, now the majority of adoptions, the adoption's sealed, the step-parent adoption has the same effect. The last one I sued the state on, the young man knew his birth mother, but his birth certificate was changed by his stepmother. His birth mother was a fully enrolled member of a federally recognized Indian tribe. He wanted to become a member. He needed his original birth certificate because it had to show the blood connection to the birth mother. We had to go through the whole process just to get a document that he knew about, but he couldn't produce. Again, People have been held up getting U.S. passports because their amended birth certificate doesn't look exactly right. It's missing some information. I noticed, in fact, in my adopted son, the time of birth was omitted. And in fact, I noticed that because this gentleman that I did the Indian, he said he was upset in school that he was the only kid that couldn't show his birth certificate and determine when he was born because his stepmother couldn't tell him. And I went and looked at my son's birth certificate that my wife and I got, and sure enough, the time of birth isn't there. But it's on the original birth certificate when you get an original birth certificate. Here's an original birth certificate that was canceled by adoption. That's the stamp that Vital Records puts on it, puts it in the file and seals it. This one was baby girl. That was the first name the person had. And that's one of the questions they ask. What was I called at birth? And as Senator Robertson said, the adoptive parents can't answer that question. And it's a basic question. You knew what you were named at birth. Every one of you who isn't adopted knows that answer. Every one of you who's adopted doesn't know that answer and has to go to court to get it. And what this does is restore the civil right to get what's theirs. And it's like if you think of a puzzle of your life and the one piece that you can't find, well, that puzzle's not done yet until you have that one piece. And I can't tell you the emotions that I've heard from clients, because I've done a number of these over the years, is how it gnaws at them that they can't fill in that puzzle. And no one was ever provided confidentiality. That's the myth that pervades this area. This is the fourth time in the last 25 years I've been before the legislature, and we've lost every time on the myth that the mother was provided confidentiality. The word confidential, secrecy, whatever, it doesn't appear in the code anywhere, never has. Up until 41, adoption records were open. If you want to look for an early adoption, you go to a domestic docket and look up the adoptive parents' names and find them, and you won't find a child custody or a divorce, it'll be an adoption. 41, they were closed. 45, the birth certificate was closed, but it was closed to the adoptee upon, or not closed to the adoptee, it said may be given to the adoptee upon age. In 61, that was removed. Well, do you know why adoptions were closed? To protect the adoptee. The adoptee was the bastard child that was an embarrassment to society. And the adoptive parents needed protection because they took in the bastard child. And in 2014, we had a man testify here who grew up in Michigan, and he testified that as a youngster on the playground, he got beat up the day that his friends' parents told them he was adopted and they couldn't play with him anymore. It brought tears to my eyes to hear this man tell his story. That's the myth, because that isn't what everybody understands. And the law, as I say, has never promised anonymity. And unfortunately, I spent 45 minutes with Representative Daniel last year explaining to her the law, the litigation that occurred in the states of Oregon and Tennessee, went to the Oregon Court of Appeals, the Tennessee Supreme Court, Tennessee Federal District Court, all finding that a mother has no constitutionally protected privacy right to be anonymous to her child. That was 25 years ago. We've been down that road. The statutes are clear. I explained all that to Representative Daniels, and she said, well, I was told by an attorney that I was entitled to privacy. And I said, well, that was a lie. Well, she has continued to repeat that lie. Well, if you repeat a lie long enough, unfortunately, some people will start believing you. But I'm telling you that it's a lie. There is no privacy right. And if you look at the origin of the why, there was no reason for a privacy right. Unfortunately, if you ever saw Dan Rather's expose on treatment of birth mothers in the 40s and 50s and 60s, it brought tears to my eyes when I saw how these mothers were treated. They were an embarrassment to society. They needed to give up their child and get on with their life. And birth mothers were told, forget this event, go on with your life. Well, if any of you has given birth to a child, and certainly as a father has had a child, you don't forget that event. And it was poppycock to think that that was our social model. Well, social workers now have recanted that model. And you spoke, Senator Silcock, Representative Silcock, about the health, mental health. Well, they've determined how good mental health is in understanding openness and adoption. Excuse me for going on too long. But
Any questions for Mr. Outman or Ms. Weiss? Representative Hong.
Just curious, do you know how many states have it this way that we're trying to propose?
15 are exactly like this bill, and there have been no reported issues in any of those states.
Alabama opened theirs in 2000, no problems. As I say, Oregon and Tennessee. There were 7 states that never closed, or 2 states that never closed their records.
Kansas and Alaska.
Alaska and Kansas. And another myth is that abortion rates will go up. The statistics are opposite that from those states.
Any other questions for these two witnesses? I will say this, in this subcommittee and definitely in subsequent hearings, don't say a representative lied. I'm just going to say that. I know the representative you referred to, and I know she wouldn't, willingly lie. So just I didn't want that to go unsaid.
Excuse me.
Mr. Chairman,
Sure.
I appreciate when witnesses come in here and tell us the truth, and everybody's also entitled to their opinion, and this is a very learned expert on this issue. The representative he's referring to, as far as I know, is not. But I don't want our witnesses to come in here and censor themselves. I want them to give us the truth. So I appreciate you,
Well,
Mr. Altman.
I do too. I want them to tell us the truth, but I think it's not necessary to say that a representative is lying about something.
Excuse me.
I mean,
I said
if
she
some-
repeated the lie.
Yeah.
I guess that implies she lied, but I mean,
Just the point could be made without
thank you.
saying that. I think that would help the argument. And
Duly noted.
certainly, I think you gave a lot of good information, but I'm just saying that there are going to be more lawyers at the next committee as this goes on, and then even more in the House. And I think, House rules address that on the floor, and I think it's good to do that in the subcommittee as well. So thank you for your testimony. I appreciate you coming. If more people had that flow chart that you had about the options on legislation, I think we'd get more done around here. So thanks for the good analysis. All right, next witness, Teresa Garcia Robertson.
Good morning, Mr. Chairman, members of the committee. My name is Teresa Garcia Robertson, and I'm here as a private citizen and as an adoptive mom. My daughter will be 5 next month. Her name is Andy, and she is a delight and the joy of our family. When Andy was born in Columbus, I had the privilege of being in the room with her and coaching her first mom through labor and delivery. And I had the Piedmont Hospital was incredible and celebrates life with us, and it was an incredible experience that was heart-wrenching and beautiful, and something that I could never have anticipated walking in as any parent. But you don't know the mix of emotions that you will feel when you are not personally the person giving birth, and you are watching a woman who you admire and end up loving, who made a choice for her child and for herself to choose you to parent her child. So we go through the process of Andy's first mother relinquishing her rights, and we were the ones who walked out of the hospital with someone in our arms, and she was not. We were given Andy's original birth certificate, and we were also, when her adoption was finalized, we were given her amended birth certificate. And our lawyer was also an adoptive father, and so he understood what he was doing and knew that we would want both copies. if I was irresponsible, if there was a fire, if there was a flood, and those birth certificates were lost, I could very easily go to Vital Records and get a copy of Andy's amended birth certificate. However, I would have to wait until she was 18 to hire an attorney and petition the court in order to get a copy of her original birth certificate. We have an open adoption. I have a relationship with Andy's first mother, which is a privilege and a joy. But we also have 2 older children. We are your stereotypical, at this point, modern family. We are blended on every level. My husband has 2 adult children from his first marriage, and so I'm a stepmom there, and I'm an adoptive mother over here, and I love sharing all of these kids and having a family that just loves all of our children, and we are a family. But what I find incredibly hard and don't exactly know how to explain to Andy, as it is already difficult to explain that Sarah and Seth's mom is not Andy's mom. I don't know how I'm going to explain to her that in a family where we're already all mixed together and everybody is just loved by everyone, why her older brother and sister can go to Vital Records and just get their birth certificate, and she's going to have to go to court to get her original birth certificate. There's an inequality there. And so how do I explain to my daughter that in the eyes of the law, it would seem that she's less than because she is adopted? I don't want to have to explain that to her, and I shouldn't have to, in a state that is very quickly becoming the number 1 state, the state that is looked at for how to do adoption and how to do foster care, for a state that talks about the sanctity of life. A part of that is your entire story. It's not just the breath that we breathe. So I want us to do this part well, too. I want us to show kids that this, and families, adoption is important in this state. Foster care is important in this state. Foster kids can immediately get their birth certificate when they turn 18. It's just handed to them. But simply because our daughter was adopted and we officially became a family and we officially gave her our name, that right is taken away from Andy. So I would like for us to really prove the point and truly be first in the country for adoption and for foster care. And I would like for my daughter to be equal to her siblings in the eyes of the law. And so I would urge the committee to support SB 64 and pass it to full committee.
Thanks, Ms. Robertson. Any questions for this witness? All right.
Thank
you
you.
for testifying. Courtney Humbaugh. Waves, okay. You support.
I'm an adoptee and I'm in full support of
Thank-
SB 64.
Thank you for coming to the Capitol. Rosemary Lee. All right.
Yeah, she's a first mother and fully support.
Full support, fully support.
Thank you, Miss Lee. Lila Bradley.
Good morning.
Thank you, Miss Bradley.
Thank you. So I'm Lila Bradley. I'm a graduate at the University of Georgia School of Law. I've been practicing law for a long time. For the last 10 years, I've been an adoption lawyer. For the 10 years prior to that, I worked as a child advocate attorney in the Fulton County Juvenile Court. And so the last 20 years has given me a real broad perspective on first mothers, on birth mothers. And so I want to be a little bit bold to speak for some of them. I can tell you in this 20 years where I've been interacting with and sometimes representing women who were either voluntarily surrendering their rights or having their rights involuntarily terminated so that their children would eventually be adopted. I've never known one of those women to ask for anonymity. In fact, what I get asked on a regular basis is, will they be able to find me if they want to? And so I just think, I really want y'all to hear that. I also represent a number of adult adoptees that range in age over the last 10 years, from I think the youngest I worked with, because it costs some money to hire me to do this, I try to keep my fees as low as I can, but I have to pay the rent and pay the paralegal. The youngest, I think, who's ever hired me to unseal their records and obtain their original birth certificate was around 40. The oldest was someone last year who was 66. And so that was really fun to be working across that span. Most of the people who come to me asking to unseal their records and get their original birth certificate, most of them already know who their birth mother is. Possibly they know who their biological father is, but they want the documentation. This is the government documentation of their birth, and they want that record. And when I've helped them obtain that, Jim also reported the emotions that I observe and that they share with me are powerful. And in none of those cases have I ever observed anyone using that information to, cause any kind of harm or embarrassment to the biological family. In fact, I think what causes more harm and embarrassment to the biological family, frankly, is Ancestry.com. They have counselors on staff to help people who have found out through the DNA testing about biological connections. And I think that's a shame that that's where people have to go. So, happy to answer any questions.
Thank you, Ms. Bradley. Any questions for Attorney Bradley? All right.
Thank you.
Thanks for testifying. Do we have anyone who didn't get a chance to sign up who wanted to testify about the bill? All right. Senator Robertson, your bill's had a thorough hearing here. Do we have any motions?
Make a motion to pass.
We have a motion due pass and a second. All in favor, say aye.
Aye.
All opposed. All right. Congratulations. Your bill goes on the full committee. And I forgot to tell Senator Dixon, we're on for 1 o'clock today, right? 1 o'clock today. Full committee, 1 o'clock today.
Thank you.
Thank you. Appreciate it.